Father, we thank you for this day. We thank you for this time together. We thank you because your presence and your spirit is here. You are in the midst. And we are excited, Father God. You told us to get wisdom, to get understanding. So we're here today to do just that. And Father, we thank you for the life that we live. We thank you for the resources that we have. And we thank you, Father, that you are preparing us to be able to prepare those that come after us. So we just appreciate you. We thank you. I lift up every person who has taken part in planning, in presenting. All of it is for your glory, and I ask, God, that you honor them in every area that they may need. In the mighty, matchless name of Jesus Yeshua the Christ, we thank you and we pray. Amen.
Thank you, Sister Bess. On today, we have two presenters. One is Dr. Val White, and the other one is attorney Kimberly McAuley Russell. Now, both of these ladies will come to you with a lot of knowledge about making your plans for how you want things carried out in your life. It is very important that we do have this conversation because so many people leave us and we're scrambling to find where's the will, what's happening with my money. I thought it was this way, but if you put everything together and have it in a place where your family can find it, you'll make things much easier. As most of you know, I just recently lost my mom, and we did all our pre-planning 2 years ago. And thank goodness we did, because at the point of time, it was very hard to get everybody together to have done the business that we needed to do. And we did it in a time when we were calm and collected and we weren't all over the place. So for today, Dr. White, she has extensive hours in helping people plan their estate. And Attorney Russell recently got her license to do just that, to do wills and trusts. I hope today that you ask questions, don't be afraid, and I'm praying that they will make things clear for you so that you will understand when you leave here, you will know exactly what you need to do in order to get your estate in order. Some of you, and we tried to get one to a family, the first part of it is going to be from Dr. White, and it's a way to keep track of everything. When you are starting to look for an attorney, this is not that you have to use Kim, but if you choose to use her, that is fine. Before she got her license, I had just gotten mine done. And I can tell you, I paid a lot of money. And don't let that discourage you from doing what's right for your family. I did my homework, and I found out I was paying about what was average nationally. So when you talk to her individually, she will give you her prices. At the end of the day, when you leave, there is a sign-in sheet if you would like her to contact you because you want to ask her more personal questions about you and whatever your situation is, then please leave your name and your telephone number, and Kimberly will get back in touch with you to answer your questions or to set up an appointment so that you can meet her personally. So first, we're going to start off with Dr. Val White, and she's right behind me.
Okay, good afternoon, everybody. Um, I'm going to present some very, very, very valuable information that everyone should take account. I'll give you a list of things that we should put together for our families. I'll tell you step by step how to organize funerals and what everything that has to be done during that particular time. The Boy Scouts had a motto of be prepared, and that's what we should take to heart. We should be prepared to put all of our affairs in order so that, well, you know you got to go. We don't want to go. Well, some of us might, but I know I'm not quite ready yet. But it's something that's going to happen. So you want to make sure that you have your affairs in order. All right, now talk a little bit about why this is important. As Pam mentioned to you, funerals and deaths are extremely stressful. When the time comes, you don't want your family to be stressed out trying to find this, that, and the other thing. You don't want them to, you want them to love on each other, you want them to support each other, but sometimes if they don't know what's going on and they don't know your wishes, it can cause rifts and strife among family members. And they might not ever speak to each other again, and you don't want that. So to prevent your family from undue stress and even financial burdens, you want to make sure that we're prepared for all of the things that we need to be prepared for. Okay. Can you go back one more? We mentioned a few other things about the why. Um, Families can disagree about certain things, whether or not to cremate you or have a burial. You need to make sure that they know and understand what your wishes are, so when the time comes, um, everybody understands what's going on, so that there's no arguments over it. And even if you decide to be cremated, well, they need to know what to do with the ashes. Somebody might want to do this, somebody might want to do this, and then there's a disagreement and an argument, and people are angry at each other. There's also various issues that can arise with the planning of your funeral. Open casket, closed casket, other things that might come up. You don't want to have your family running around looking here and there to try to find all of your information. That could be costly. If you pay for a burial plot and they can't find it, they might have to pay for it again. It might, be coming, then that's a big expense that could, be coming out of your family's pockets that really is unnecessary and they don't have to do. But if they know that you have this, then that would alleviate that kind of stress. There can also be some legal complications. Let me give you a little personal stuff. If you have a blended family, please have your things in order, and please, please, please let family know what's going on. Okay, I've been on both ends of the spectrum. All right, my parents were divorced, dad remarried, dad got killed, stepmother got killed, and when that happened, all right, they had owned a house. The house went straight to my brother, my stepbrother. I didn't get anything. Wasn't that happy about that. But I didn't mention anything to him. I didn't say anything to him. He was only 15. I knew that I had another place to stay, so I didn't even tell him that I thought I should, have a little something from that house. So I let that go. I let him have the house. Then mother remarried. Mom married a person who had two prior kids from another marriage. Their dad died. Then after my mom died, house went to me. Now, that situation did not go well at all, but I knew what I was supposed to do because we had talked about what would happen if something should happen to the both of them. I knew that I was supposed to give them a portion of the proceeds, and that's what I did. Even though the house was in my name, legally, I didn't have to give them a cent. Morally, I did. Now, the son, there were some complications with how much they were going to get because of certain things that happened, medical bills, renovating the house and things like that. The son understood that, okay? He got his piece of the pie. The daughter, I called her to make arrangements, haven't heard from her, and till 3 years later, wanting a piece of the pie. She sullied my name with the family, saying I didn't do anything for her. Of course, she never bothered to call, but she called the attorney, the real estate people, everybody else she can call, told the family I did this, that, and thing, when all she had to do, just like the son, was give me a call and we could work out the details. So 3 years later, I get this call from her, wanting to know, hey, well, look, at this point, you got crumbs. So you get what's left. So, it wasn't on me. I tried. But just know that these kind of things, even though my mother had a will, you can still have conflicts. But if family understands certain things prior to, what's going on, then it might make it a little bit easier, for the family afterwards. Now, after she got her 2 cents, haven't heard from her. It's been, 12, 15 years, haven't spoken. The son, we exchange, we're more closer now than we were before his dad passed. We exchange holiday greetings, send each other Christmas gifts, and we have, a somewhat relationship, but not with her. And I don't have any sisters. I would have loved to have had a relationship, but hey, it is what it is. Okay, so what you need to know, have prepared, make sure you've written down someplace your full name. Ladies, you also need to have your maiden name. So make sure that your family is aware of what that is. Your parents' name, including your mother's maiden name. The name of your spouse. I know, you say, well, my kids, they probably already know this. No, please write all of that stuff down, even your address, your birthday, your place of birth. Now, this information is going to be vitally important when you go to the funeral home. They're going to want to know this, all right? They're going to ask you these things. It's also important that you have this information for your estate. So after everything is over with, you have to settle your estate. They're going to also need this information for that. Now, you should have a copy. It doesn't have to be certified. A copy of your birth certificate, a copy of your marriage license, copy of your social security number. If you're in the military, your DD-214. Have that. Now, you can put all of that document, put it in a cute little folder, and we gave you some nice folders. You can stick that inside of this, and you have a place to put all of those important documents. Let me give you, I'm going to try to give you personal information, a little example of why this is important. I do a lot of family history research, And a lot of people call me if they want to know anything about ancestry. When my brother-in-law died, his uh, nephew was handling most of his affairs and things like that. But when we went to the funeral home, we were asked, what's his father's name? Well, my mother-in-law, she was one that didn't share any information, and we weren't sure. But I had done some research on family history, and I already had some of this information. I used what I had to the funeral home, but I regret doing that, okay? The reason I regret doing that is because what you tell them is an official document, and that has to be accurate. So if I'm wrong, oops, that is not going to be good. So what I should have done was just left it. If I wasn't 100% sure, just leave it blank. That's the best thing to do, other than trying to, well, maybe this is it. It doesn't have to have everything filled in if you're not sure of the information. Okay, let's go. All right, now, for your um, funeral information, it's important to know what funeral home you want to use. You might, well, just call one. Well, sometimes there's, particular ones that you want to use. Again, give you another example. My nephew, my brother-in-law died. My nephew was handling his things. He called the wrong funeral home. So that can happen. You want to make sure they know the funeral home, the cemetery, all of that information. We weren't going to change anything because, well, if you start using this funeral home, you already started with this, they're going to want their money too. So instead of paying doubly or whatever, we just rolled with whatever we had. You might want to put in your documents whether or not you want your casket open, whether you want it closed. Personally, I love y'all, but if I'm gone, y'all ain't gawking in my face. I'm sorry. It's okay. It's okay for family, go to the funeral home, take one last peep, that's it. And we can have a visitation, no problem. You come and shake hands with the family, give them a hug, but you ain't gonna be looking at me, I'm sorry. Anywho, whether or not you want to be buried or cremated, and that's kind of important. If you wish to be buried and they burned you up, can't put Humpty Dumpty back together again. That's it. It is what it is. So whatever decisions you want, just put it in writing. Make sure your family knows about it. Like obituary information. Let me back up just one second to the funeral home thing. The cemetery. Let's say you have made arrangement with the cemetery. You bought your plot. We've bought ours. We even paid for the headstone. We even designed the headstone. What's going to go on it? And we pay for everything we could possibly pay for, except something called opening and closing. Now, this is something that could be a shock when your family members go to make cemetery arrangements. You gotta let them know what's been paid for and what's not. Imagine showing up to the cemetery with a paid in full receipt. Everything has been paid for, and they tell you, well, you owe us $3,000-4,000 to dig a hole. That could be a little surprising to some families. So that's called opening and closing. Now, at the time we made our arrangements, we could not pay that. North Carolina has now changed their rules. So if you have prepaid for everything, but you didn't do that, now you can go back and pay for the opening and closing ahead of time, which is a good idea because they go up every year. That might be, something that, you don't have to, but that might be something you want to be cognizant of whenever you're making your arrangements. Okay, where am I? Nope, I'm still on funeral stuff. All right. Obituary information. Now, I don't know if they still do this, but on a lot of obituaries, you'll read about the fact that I was baptized in 19 so-and-so by Reverend so-and-so. Your family's not gonna know that. So if you want that, maybe you don't want that in there, but this is an example of some information that might be able to go in an obituary that your family would not be aware of. So if you have some information that's gonna go in there, just write it down. Me personally, I've written my obituary. I don't know where it is, but and it definitely needs to be updated. But after this, I'm encouraging everybody to be prepared. I'm gonna have to go back and re-prepare or update what I have to make sure I'm doing what I'm telling you you should do. But anyway, you might also want to have like scriptures, if some favorite ones or something that you want to have read, or a poem or whatever songs that you want. Just write that down so that the family will know. That's less stuff that they have to try to worry about how to put together. I've even got a program written. Might have to make some changes. I also got to find out what I did with that one too. But but anyway, so write things down that you would want to have. If you don't want to have that's okay. But just let them know if in the event that you do. Pictures are kind of important. You wouldn't think. My mother was a kind of person that didn't like to take pictures. She probably up there in heaven fussing at me right now because of the picture that I use for her program and her things. Well, you didn't give me one, and you didn't like to take pictures, so I picked the best ones that I could have. And then here's another example. When we went to our brother-in-law's prepare for his funeral, he was another one that didn't take pictures. And all he had was a high school graduation picture. He's in his 70s. High school graduation picture that's kind of faded. That's what they, were planning to use. But I gave him a different picture. He was in our wedding. So I cut out his picture and made a nice little picture that they could use and offered that to the family. The funeral home, convinced them that would have been a better picture to use. It's more recent. At least he looks like a grown man in the picture, and it had a little bit better quality than the faded high school graduation picture. So even a picture that you want to have, that's important as well. And you might want to change that as we, grow up, but just keep that in mind. All right, I think I talked about the cemetery information, so back. All right, it's important to have a list already made up of family and friends with the phone numbers, okay? You also need to have your employer, or if you're getting a pension, wherever you're getting your income from, already have that. Don't have your family run in to try to figure out or find these numbers. Just have a list of people to contact. Your insurance company, now doctor's name and numbers, well, that's important too, not just after you pass away, but suppose you're incapacitated and you have to go to the hospital or something like that. After they ask you where your insurance is, the next thing you want to know is, well, what's your medical conditions? What medications are you on? Now, a lot of times they have that, because nowadays they have these networks, and you go to the doctor or hospital in your network and they have all that. Even though they have all that, they still ask you. So That's good because they want to make sure it's updated and they have all of the, information, like if you don't have any new things that some doctor prescribed for you. Make sure you have your attorney's name and number, your accountant name and number. You're going to need that when you get ready to settle your estate. All right, let's see. What else? All right, let's talk about some financial information. Make a list of all your bills, your credit cards, um, uh, all of that information should be in your final documents. Um, Also, not just make a list, but again, get one of these cute little folders that you can stick with your things. Put a copy of your bill in there. That bill is gonna have, or a statement, that's gonna have your account number on it, it's gonna have the payment information on it. If you're incapacitated, this also will help the person that's trying to work with your finances. Whoever your power of attorney is, they should have this information so they know how to pay your bills. But have a list of that. Now, balances, it's gonna change. Who you pay is gonna change based on when you pay stuff off or if you get new bills. So we wanna make sure we keep that stuff updated. But if you have the statements, at least they have the contact information, the phone number, your account number, and all of that, they can figure out what the balances are. No, we're not done, not done. All right, if you have other investments, stocks, real estate, crypto or whatever, make sure you have that information. People, there's billions of dollars just floating around in la la land because with crypto, because people can't find their login information and what they call there's this seed phrase. It's like 12 words that will allow you to get into your account. I know someone who bought some Bitcoin way back years ago, 10, 12 years ago. If they had their information, which they lost, they no longer have, they'd be multimillionaires. But because they didn't keep up with the seed phrase, they can't get into their account and out of luck. Because there's no help to call. You can't call a help desk. There's no such thing. So make sure that you have that information. And even if you have some crypto that's not worth pretty anything, still have it. Maybe 5, 10, years down the line, you never know what's going to happen with that. It could shoot up, and you want your family to have that money and not have it just in la la land like billions of other people have their information. You got that cash stash, right? Our ancestors used to stick that stuff in the mattress. Some of them didn't trust the banks. You pass away, matches get thrown out because they ain't know you put it in there. Let folks know where it is. So if something should happen to you, that money doesn't get lost. You have a safety deposit box. Let people know where the key is. Now, here's something you might think of. Your family, they might know where the key is, but if you don't put them on one person, at least from your family, other than your spouse, on your records, what can happen is when you pass away, they're not going to be able to open that box until your estate is settled. So if you want them to get it right away, you need to put somebody on there. They don't have to have a key. They just need to be put on the record so that something happens to you, they can get your key and they're already on the records. They can go in there and get whatever they need to get. All right. This is something that I didn't even think of. You might want to put your car title in your documents. because that's a part of your estate that will need to be settled. And so that's something I got to go find where mine is and add that. That's a new thing that I didn't even realize until we were doing this little seminar. All right. Okay. Keeping your family informed. I can't stress enough how much how important that is, and how much you need to make sure that happens. You want peace and love, not strife. Okay. This is a complicated thing. A lot of decisions have to be made, and a lot of decisions have to be made like right now. And so arranging these things will cut down on a lot of stress in the family. You need to know where your documents are. You don't want them at the last minute to try to go figure out where all of these things are. You want to let your family know what your wishes are. And here's an important one. You want them to know who's responsible for a certain task. For example, with our family, each one, if something should happen to both Kylie and I, our kids have certain responsibilities. That's one in charge, my MBA daughter, she's in charge of the finances. She's the executive of the estate. My other daughter, planner. She's going to be planning, making all of the arrangements, taking care of the house and all of that kind of stuff, making the decisions involved with that. My other son, he has the health care. You can't count on those girls to pull a plug. I don't want to be a vegetable the rest of my life. So my son is in charge of that. Now, they all have input, okay? But the final decisions rest on the people who's in charge of certain things. So you might want to make sure that people understand that kind of thing and know who's responsible for what. In some states, they have this thing called appointment of disposition. It's actually a form that you can get notarized that designates a certain person. Well, if there's a dispute, this person has the final say. So that might be something. You might not have to go fill out a form or get anything notarized, but maybe put in your notes that, hey, look, we want to have peace. If there's some conflict that arises, so-and-so is going to be the one to settle it. All right. You want to know how your funeral and everything is going to be funded. Well, you got your life insurance policy. Maybe that doesn't cover everything. Well, where's the balance going to come? Is it going to come from your bank account savings? If there's nothing there, your family going to have to come out of pocket. We don't want, but hey, some people do that. But if they just need to know what it is, how it's going to be funded. Your possessions. Okay. Well, what's going to happen with your home or your property? Is it going to be rented? Is it going to be sold and they split up the whatever? Is a family member going to live in it? Kind of give them some direction as to what your wishes are, but sometimes that's a little gray area where that might have to be worked out, afterwards, because things change and situations change. But just point them in the right direction, have a talk about it, so that there's not a big to-do about your property after you're gone. Maybe, I don't want to out my husband, I'm going to get it when I get home, but hubby has an extensive watch collection. Now, because it's men's watches, you might think, well, the boys will divvy that up. But maybe my girls might want a couple of his watches or something like that for a keepsake. So what's going to happen with your jewelry? You might notice I don't wear it. All I got is my wedding band. I don't have nothing flashy, so not too much to discuss there. But just let people know what's going to happen with your possession. Just have a little chit-chat about what. And then there's other household things. What do you want to do with your furnishings and paintings or whatever valuables you might have. All right, now, Kyle and I have written our autobiographies. And in these books is anything and everything our kids would probably ever want to know about us. Kylie, can you circulate? Okay, so I'll pass these around later on. But in here we have family pictures. We have some of our wedding pictures, the childhood homes we ever lived in. We have every church we ever been a member of. Uplifts in it, the old building, it's not the new. Baby pictures, every school we ever attended, every place we ever worked. Ooh, don't look at that, y'all. Just a whole myriad of information is in these books. Now, I'm not telling you got to go out and do an autobiography or have something as elaborate as this. Oh, she's going to pass these around. Now, my book has some paper clips in it. Don't remove my paper clips. We're going to have to fight later. But anyway, but just write down some information about your life. It's going to be important to your family. Even if it's not important like right now, down the line, your great grandchildren, it'd be nice to know that information about you. Okay, as I mentioned before, I'm pretty heavy into family trees and family history. And this is really, 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 well, to me it is, and hopefully it's important to you as well. Catch up. I have been doing a lot of research on my ancestors trying to get on the Mayflower. I spent years. I've even gone to Boston to look up information, attended workshops, a whole lot of things. Well, you have to have, they call a direct line. Well, I couldn't find a direct line, so I'm not on the Mayflower. But I do have some uncles and an aunt. Got close, but if you don't have a direct line, you can't be on the boat. So because I did a lot of extensive work and I have a huge ancestry tree, I was able, we found out about something called GU 272. Now what that means is Georgetown University, 272 is the number of enslaved people they sent to Louisiana. Well, I never thought about how my family ended up in Louisiana. That's why they ended up in Louisiana. That's some good information, some historical information. Now, if I hadn't been keeping up with these records, I would not have known that I was a member of that. So what? You're a member of 272, you know how your ancestors got to Louisiana. Here's the important thing about that. My descendants now have, well, let me put it this way, may have legacy admission to Georgetown because of GU 272. They don't have to qualify, just like everybody else, but they have legacy admission. Also, Georgetown has set up a foundation. They funded a foundation. They can get scholarships from that foundation. They have to apply for it. There's certain rules and regulations, and there's certain numbers of people that can get a scholarship every year, but that's available to them. Even our elders in our family, if you're struggling and you can't pay your light bill, apply to the foundation, and they can give you some money to pay your utility bills or whatever, so you don't cut your power off. But if I had not done the research on my ancestors, not have, known about all of this. Um, and another thing that's happening right now, last year, Canada passed a new rule, a new law, I should say, on immigration. You can become a Canadian citizen if you have an ancestor that is a Canadian citizen. Since I had my extensive ancestry research, all I had to do is just flip through, oh, here's my Canadian. Now I'm in the process of applying for citizenship in Canada. I have the line of succession that I need, all of the ancestors that I need. I just need the documentation. I've already sent off more than half of it. I got some more work to do, but I'm in the process of working on that. But had I not had the research already done, might have been a problem. So I think it's important that even now, I don't know, those of you who are currently in the school system, they used to give kids assignments about fill out your family tree. So all of this information is there for my family to have. So I think it's important that you do a little history. Now, as you can see, got my tree up here. I know all of my grandparents, all of my great-grandparents, all of my great-great-grandparents, a whole bunch of stuff. I can trace my enslaved people all the way back to the 1700s. A lot of people can't do that. That's because of GU 272. They have official records of that. Also, my other ancestors, European-style ancestors, I can go back 1400s with them. And I could go further, but that's kind of where I stopped doing the research. Matter of fact, I considered applying, writing a letter to the Queen before she passed away to get my title. I am a descendant of the Royal British family. You can call me Lady Val. Well, feel free to do that. But since I didn't get my official thing, well, okay, I guess you can't do that. But anyway, so I'm just, sharing this information with you so that you can see that it's not just putting together a bunch of ancestors. It can be very important to your family to know a little bit about their family history. Oh, no, you don't have to go back, but just to tell you the thing, I can't do that for Kali. Because his family is tight-lipped, they don't want to share anything. I might not even have all of his grandparents. That's to me, that's kind of sad. And I definitely don't have all of his great-grandparents. We've been searching, we've been trying, but we can't get very far at all. He doesn't like that. He's not happy. But anyway, all right, so in a minute or two, Ms. Russell's attorney is gonna come up and talk about some wills and trusts. It's very important that you have one or the other, whichever one you so happen to choose. You need to have your power of attorney. I explained to you what happened with my mom because we didn't have the right one. I thought I had it, but you need that durable power of attorney, the one that's gonna let you do the finances. Told you about the healthcare proxy. If you can't do anything for yourself, and then you need to have your executor of your estate. Next, please. Don't forget to update. Now, that's my biggest problem, okay, is keeping this stuff updated. You want, especially with your bills, you pay off bills and no longer have that bill. You made new bills, or you got a divorce. Pray that doesn't happen to you. But if you put a beneficiary name down for someone you used to be married to, you might want to make that change. Because if something should happen, it's too late. Whatever's on that piece of paper is what's going to happen. Or, so things like that. So you want to make sure that you keep all of your documents and things updated. Now, I know that we have talked about, guys that have these folders, these little dividers are kind of like sections that I've partitioned off. So if you flip that over now on the yellow section, we know what documents to have. We know why we need to have them. We know that they're very important. But now, if something should happen, you may or may not have experienced arranging somebody's funeral. So I got a step-by-step guide here that tells you what you need to do in order to plan your funeral. If somebody should we're on the page right after the yellow. If someone, and there's no slides for this one. If someone should die, if they die at home, you still got to call 911. Somebody's got to come over and pronounce them deceased. They got to get their time of death. You've all seen these TV shows with the doctors, time of death, so and so and so. That's a legal record thing. That's a legal thing that has to go into records. So that's kind of important. If it's in a hospital or a nursing home, they know to do all of that. You want to notify your loved ones. Well, not a big deal. Why? Because you already have your contact list. So you're good to go. All you got to do is execute it. You want to contact the funeral home. You already know which funeral home to contact. You already have that information. Just execute it. You don't have to look for key documents because you already have it. We gave you these cute little folders. You can, use this and put some of your things in. So you already have that information. Death certificates. I'm in the book now just in case you guys don't know where I am because there's no slides on this one. The death certificates, make sure you have enough. If you have 5 banks, every bank is want a certified copy. You can't just, I just make you a copy. No, you got to get one of those copies with the little stamp on it. So you get that from the funeral home. They'll give that to you. Every insurance policy you gotta have a certified copy. Family members may want a certified copy. Just maybe they had an insurance policy on the side they didn't tell you about. Well, I don't know. I'm just messing. But anyway, just make sure you get enough. Then you're gonna start to make the arrangements for the funeral, memorial, whatever it is you're having. Because you've written the information already, you already have all the information that you need. The notified employees, you have the information you need for that. The financial tasks, you're going to contact the banks and all of that. Whoever's the executive of your state, now is when they start going to work, taking care of some of these tasks. Number 9 is very important. I want to spend a little extra time on that. The Social Security Administration, there's a sheet right behind this one, I think, somewhere in there, or it could be in the next session. The Social Security is so generously going to give you $255 for your loved one. That's been like that for 100 years. They have not increased that. Now, that might not even pay for the flowers. But, well, it's $250 more than you already had, but just so you know. The important thing about this, and you can read through this, I'm not going to go through everything on here, but I do want you to understand that it's important for you to notify them immediately. You don't wait 4, 5, 6 months to notify Social Security, because those checks, if they're being direct deposited, you have to get that money back. And if you spent that money, somebody's going to have to pay it because it's going back. All right, so that's what I wanted to make sure you were aware of with the Social Security. Military, there's a sheet in here right behind the Social Security thing that talks about the military. Now, the government, if you are a veteran, you can get free burial, but you got to go to one of these military cemeteries. They'll give you the marker and everything. They'll how they fold up the flag and hand it to you. They'll have a little presentation and all of that stuff. But you need to have that DD 214. So make sure that that's in your records in order to get these services. There's a lot of other important things over here. I'm not going to go through all of that, but you can read if you're a veteran, and you can just look through that and see what you're entitled to. Now, the other thing, and I'm back on the sheet of step-by-step what to do. Number 14, ooh, that's a big one. You thought because you died, you don't have to pay no more taxes. Sorry, I don't care if you are dead, you're going to pay some taxes. Government want their money. So there's a sheet in here that tells you how to file your taxes after you're gone. I think it's behind the orange paper. So I'm not gonna go through, how all that works. You can do that for yourself. But I just wanted you to know or realize the fact that you're gonna have to, not you, maybe not you personally, but whoever's over your estate, that's gonna have to happen. All right. So let's see. I think that's now. This next section, you have this little booklet in here. I am not promoting Colonial Penn. Trust me, I don't like these folks. You can get a life insurance for $9.99. Yeah, right. $1,000. Okay, that's it. Not gonna go very far. But they do have a nice downloadable packet of pre-planning. All of the stuff, we talked about recording your bank accounts and all of that stuff. You can use this little guide for that. Now, we do have a will that we already, have made. I might want to change it to a trust, but we've had all of that done. I have most of my documents. I don't have everything I talked about, but we do have in our little folder all of the important things that we need to have. And then the books are going around that if family ever want to know anything about what we're, information about us, they have it. That brings me to the end of my presentation. I hope this was very helpful to you. And again, I just want to make sure that I drill into you. Please be prepared. So our next speaker, we're going to have our in-house attorney come up and share whatever she's going to share with us about wills and trusts. Thank you very much.
Good afternoon, everyone. Thank you all for coming out. Let's give Dr. White another hand. And remember to be prepared. So I am Kim McAuley Russell, and I am the owner and founding attorney of McAuley Law. And I have been licensed in North Carolina since 2010. And I got into law because of my grandma. When she used to live in, it used to be North Charlotte, now it's called Noda, Plaza, Midwood, all that stuff. And when it was being gentrified, her house was kind of taken over. The landlord sold it. She had lived there 30 plus years, and she had no recourse, right? So she kind of inspired me to get into the law to help people. And so I briefly did criminal law, hated it, don't recommend it. Then I went into corporate compliance, and then she inspired me again because she passed away. And I did her will, everything was in place. And then she had, mental decline, cognitive impairment, and we have no idea where she placed any of those documents. Everything There was stuff everywhere, finding stashes of money everywhere. House was in disorder, disarray, and we just couldn't find any of the documents. And because we couldn't find her will, and because I knew I wrote it, and I knew what she wanted, and I knew what her wishes were, but we just couldn't do it the way she planned it, the way she wanted it, because we didn't have the will. And once we went through that process, and it caused family drama, lots of stuff, rifts, all kind of stuff happened. And I was like, you know what? I need to get into estate planning. Our people need to know what the process is and why it's so important for us to get our affairs in order, why we need to have a plan, why we need to be prepared, why our family need to know our wishes, because if they don't, it is disorder. It is chaos, and it can cause rifts in families, and then we'll start having seeds of bitterness and unforgiveness, and then we aren't able to be effective disciples of Christ because we didn't plan effectively, because we didn't use the wisdom and the knowledge and the resources that he gave us in order to just do and plan our estate, because we know we're going to pass away. We know we're going to pass away. That is one thing that we know, that is a promise, right? We just don't know when. But if we plan today, if we plan now for that eventuality, then everything, we can have the peace. Our families can have the peace. Our families can have the understanding and knowledge that everything will be okay. So, next slide. So why estate planning matters? That's why, right? The Bible tells us in Proverbs 13:22, a good man leaves an inheritance to his children's children, but the sinner's wealth is laid up for the righteous. Estate planning protects your family and your legacy. Estate planning provides a peace of mind for you and your family once you pass away. And estate planning ensures your wishes are followed. So it says, a good man leaves an inheritance to his children's children. And when we think of inheritance, sometimes we think about money and assets and, things that we can touch, which is always true, right? That is true. But also think of the peace that you can leave your family. Think of the love that you can leave your family because they knew you thought about them. Think of the wisdom and the character that you can leave to your children's children because they can look up and say, my grandma, my grandpa did this, so I want to follow in their footsteps because they followed Christ. That is also an inheritance. It's just not about the things, right? It's about the wisdom. It's about the peace. It's about the good character. It's about the love that you can also leave to your children. So now that we know why we need to have an estate plan, what it can cause if we don't have an estate plan. So what happens if you die without a will in North Carolina? Your property will pass to your heirs via the law of intestate succession. So what does that mean? Intestate means you died without a will. You had nothing in place. Succession means that the next heir in line will inherit. And the heirs are determined by the law, which means generally if you're married, it'll go to your spouse, everything, right? Or if you don't have a spouse, it'll go to your children. If you don't have children, it'll go to your parents. If you don't have parents or they're deceased, right, it'll go to your siblings. So the problem with this is you might not want it to go to your sister or your brother. You might not want it to go to your kids, right? You might not want it to go to whomever. So if you have an estate plan in place, if you have a will in place, then you can ensure that your wishes are being followed and that your assets are going to who you want them to go to. And so is estate planning only for wealthy people? No. Estate planning is for everyone. If you have a bank account, if you have a car, if you have something, you need to have your wishes put into something so that your family knows what you want, how you want to distribute it, where you want it to go to. Even if it's $2, they need to know those $2 are going to so-and-so because I said so, right? Because that's who I want it to go to. And so, next slide. What age that you begin to have a plan? I personally recommend between 18 and 21 because that's when you're, graduated college, you're getting your first big person, your adult job. You probably have a car, you got a bank account, you got something going on, and we never know what's going to happen. God forbid something happens to someone that young. However, you don't want your parents to be going through a process of deciding your estate, of settling your estate because there wasn't a plan. So I say start that young and then update every 3 to 5 years as big life events happen, right? As you get married, as you have children, as you get divorced, as you have grandkids, as things happen, update your plan every 3 to 5 years. So new jobs, houses, increase or decrease in income, every 3 to 5 years, make sure that you are updating your plan so that it can grow with you and your family, and you can make sure that everything that you plan for happens.
So all the good stuff goes to somebody, but what about the bad stuff, like debt or?
Okay, yeah. Your debt doesn't die with you. So when you have a will, right, it has to be probated. But I'm going to get into that too. But so it's open to creditors, and so any valid debt has to be paid. Any valid debt has to be paid.
That includes student loans?
I think I don't know, yeah, probably. I think after a while they get forgiven, but hopefully you live long enough for them to be forgiven. Praise the Lord. I'm waiting on that too. But I think, any valid debt, so medical debt, credit card debt, any debt, mortgage, right? It doesn't die because you did it. Your family or your estate, right, will have to carry that or have to pay it. Okay. All right. Next slide. So what does an estate plan consist of? It has a will or a trust, a healthcare power of attorney, a durable or financial power of attorney, an advanced healthcare directive, or living will, which is what we call end of life kind of continuation planning, so that if you're incapacitated or you're in a mental decline, you can tell the doctors and everybody else how you want to continue your life, and a HIPAA release form. And we'll get more into all of that later, each specific document, but we're going to first start with wills. So a will, also known as a last will and testament, is a legal document that outlines how a person's assets and affairs should be handled after death. So what does that mean, right? It distributes your assets after death, meaning it is only effective once you pass away. It is not effective during your lifetime. You have to create it during your lifetime, of course, but once you pass away is when all of the assets will be distributed to your heirs that you named in the will. It appoints an executor to handle your affairs after death, or it was also called a personal representative. So a personal representative or an executor is someone who will handle and transact the affairs of your estate. And it's very important that you choose this person wisely, because they will follow the wishes that you have placed in your will, or later your trust, right, when we get to that. But they have to be someone that not only you love, but you trust to follow your directives, to follow your wishes. They have to be someone who is wise enough and has the wherewithal to go through the process of doing everything that you have laid out in the will, and not only in the will, but following the legal process of everything that they have to do in order to open the estate, in order to distribute all the assets, and then in order to close the estate, which is a process called probate. And I'm gonna back up a little bit. When you die without a will, you have to go through probate. You have to appoint an executor. Your family can either appoint an executor, or the court can appoint an executor for you, and it can be an upstanding member of the county that you reside in. A will has to be probated, period. So if you die without a will, your estate has to go through probate. If you die with a will, your estate has to go through probate. With a trust, your estate does not have to go through probate. So,
as the moderator, if we can use the mics I've passed around, that'd be the best way for people online to be able to access this later.
and her question was if she has a will the estate have to go through probate? And yes, the estate will have to go through probate even if there is a will. So, who should you choose as your executor? Someone you love, but most importantly, someone you trust to handle your affairs. Can you disinherit someone? Yes. Except in North Carolina, you cannot disinherit your spouse. The law says you cannot disinherit your spouse. They have to have at least a percentage of your estate, but you can write in your will, I intentionally omit this person. I don't want them to receive anything. You don't have to give everything equally to anybody. You can give what you want to whom you want it to go to, right? You can leave different amounts to different people. You can leave some to one child. You can leave some to another child. You can do whatever you want in your will because it's your stuff. So when you choose an executor, it is also important that you choose some backups because your executor may be unable or unwilling to serve. So what happens if your executor passes before you? They're unable to serve, right? So it's important that you have someone as a successor executor, right? Another person that you trust, another person that you love, someone that you're able to trust or to handle your affairs once you pass away. We have a question?
So you mentioned if you didn't have a will and you didn't name an executor, that someone in the county would be appointed?
That can be. Your family can also
So my question
elect an
is,
executor.
Like, I personally don't have any family in this state. So, and definitely not in the county. So, could I have an executor who's not in the state?
Absolutely, yeah. But they would still have to transact business in Mecklenburg County. They would have to contact the Mecklenburg County Probate Court, and then it's a whole process. They would have to, everybody else who could be a potential executor would have to send in their right to renounce the appointment of executor, and then they would be appointed executor from that point, and then they could transact the business of opening and closing your estate. So yeah, they don't have to reside in the state or even in the county, but they do have to open the estate in the county in which you resided in or which you held property in. Okay. And yeah, a will has to be probated. So what is probate? So probate is the process by which a will is validated and the executor is given the legal authority to transact business on behalf of the estate. What does that really mean? So in North Carolina, a will has to have certain components in order for it to be valid, in order for it to be legal. And so for a will has to go through probate so that they can check to make sure that it is valid, so that they can check to make sure that according to the laws of North Carolina, this is a legal will. And so in North Carolina, a will has to be signed by two witnesses, two disinterested witnesses, meaning that the people who are witnessing your will and signing it cannot inherit from the will, right? They can't be someone who's an heir of the will. So it has to be two disinterested witnesses. It has to be signed by two disinterested witnesses, and it has to have a self-proving affidavit, which is a form saying that I am of sound mind and I am over 18 years of age, and these people have witnessed me signing and I this will, and it is my last will and testament, right? It has to have that. It has to be notarized, and it has to have certain components, right? It has to have whether or not you want an executor, whether or not your heirs and your bequests and what you're devising, and it has to have certain components. That's why it has to be probated because they have to make sure the will is valid, because sometimes wills aren't valid. Sometimes somebody scribbles something, which North Carolina does accept handwritten wills, which the legal term is holographic wills, but they have to be meet specific requirements in order to be a valid will. And most often, a handwritten will is not going to be valid because it wasn't found amongst certain things. You have to have a handwriting expert. You have to do all these things to ensure that the will is valid. So that's why wills have to go through probate. And then once it's presented to the probate court, they open the estate. And then they give your personal representative or your executor a letter. It's either called letters testamentary or letters of appointment if you don't have a will, right? And then they can take this letter to the bank and say, give me the money so I can give it to the heirs. You can take it to, if you want the house sold, now you have the authority to sell the house. So they have now the legal authority, because the court and the law in the state of North Carolina has given them the legal authority to transact business on your behalf. And that's why it's super important to choose an executor who you trust, because they have to do a lot of stuff. And not only do they have to do a lot of stuff, they have to do it while they're grieving the loss of a loved one. So it's important that you choose someone who even though, life is happening and a lot of stuff is going on, but they're still able to do what it is that you need them to do and what you have wanted them to do. And probate can take, it depends on the size of your estate, right? It can take 6 months, because you do have to wait 30 days from the date of the person dying to even open it. So that's at least a month, right? And then in Mecklenburg County, they're a little backed up. There's a more populous county, right? Some of the other counties might take a little less time, but it can take up to a year or more to close and settle the estate, because there's a lot of stuff that you have to give the court. You have to have the estate open for so many days. You have to give notice to creditors. You have to publish it in a newspaper. You have to do all these things. So probate can become expensive, because not only do you have to have a court fee, which is $120 to open the estate, then you have to run the publication in the newspaper, which I think is between $40 and $60. I can't remember off the top of my head right now. Then you have to do an accounting, which is 90 days after you open it. You have to do an accounting and then pay 0.004% of the estate value. So there's a lot of money that goes into probate, and that comes out of the estate, or it'll come out of the pockets of your loved one. So probate can be expensive depending on the size of the estate, right? Can your family avoid probate? Of course. There's things you can do to avoid probate. There's things you can do. You can get a trust. You can do joint ownership with rights to survivorship. There's a lot of things you can do. But if you have a will, it has to be probated, because the state of North Carolina has to make sure that it meets the legal requirements of a will. So what assets do not go through probate and really don't need to go in a will? Things like life insurance beneficiaries, right? That passes directly to the beneficiary once you pass away. You don't have to put that in the will, because it goes directly to the beneficiary. They're already named, doesn't have to go through probate. Things like bank accounts that have joint ownership with rights to survivorship goes directly to the other joint owner. Doesn't have to go through probate, because there's already a person named, and that's the legal requirement that the other person was named. Things like if you own a house with a spouse, that in North Carolina is called tenants in commons, or sometimes another joint ownership with rights to survivorship, or joint owners with rights to survivorship, it goes directly to the other spouse, because that's the law. It goes right directly to them. There's not another process involved that has to go through probate. So there are some things that you can do to avoid probate, but a lot of things are going to have to go through probate if you have a will. Yeah, every will must be probated. Next slide. So now, that's wills. The other part of an estate plan is trusts. And I know we've heard a lot about trusts, especially in our community, about generational wealth and how it's protected by trusts and all these things. So what really is a trust? A trust is a legal document that allows for a third party or a trustee to hold and manage assets on your behalf while alive and after death. So like a will, or unlike a will, a trust is effective immediately. A will is only effective once you pass away. A trust is effective while you are living. So what happens in a trust? You go and you open a trust, right? It's kind of like a will in the fact that you're saying, I want this person to have this. I want that person to have that. I want, this to go there. I want that to go there, right? You're giving away your assets and you're making your wishes known. However, the trust is a legal document in which either a third party or a trustee will manage the assets, and the trust owns the assets. So, the most popular trust is a revocable living trust, meaning you can change it, you can revoke it, you can amend it, right? Living mean you're alive while you have the trust. And now that you have opened this trust, right, you as the trustee, right, you're the grantor, meaning you grant the trust permission to own your property. And you're the trustee, meaning that you are now the person who manages and controls the assets in the trust. So it can be a little complicated. So here's an example. Say you own a house and you open a trust and you want this house to be in the trust. So you say, okay, I am going to put my house in the trust. So what you would have to do is put the deed out of your name of the house. You would take it out of your personal name and put it in the name of the trust. So I own a house, right? And instead of it being a property of Kimberly Russell, right, it would now be property of Russell Trust, right? And so as the trustee, I no longer own it. The trust owns it, but I still maintain control of the house. I can still sell it. I still gonna have to pay taxes on it. I'm gonna still have to do all the things that I would do. However, instead of me owning it personally, the trust owns it. And that's how it avoids probate, because the trust can pass directly to the heirs in the trust, directly to the beneficiaries in the trust, because that is the way the law is set up. It doesn't have to go through probate because the trust owns it, I don't own it. But I still maintain access to, control of, and all the things that need to go on in the trust of the house, right? Because I am the trustee. While I'm alive, I'm the trustee. Looks like y'all got some questions.
Yes, I just want to say, recently, when I sold my house, you can still sell your house if it's in a trust, and then when you purchase the next house, that goes into the trust. But it has to be legally done through your realtor and the lawyers.
Yes.
So you can buy and sell many houses as you want to with that. Start out with one house and I'm moving to another. So it does not affect, I gotta stay here just because this house is in a trust.
Right.
I heard you say that it's not Kimberly McAuley Russell, right? But then the trust is in Russell. I'm confused.
So the name of the trust, right?
Just change the name.
Yeah, the name of the trust can be whatever the name you want it to be. It can be Green Frog. It can be Orange Duck. Whatever you want the name of the trust to be, it can be, right? So I'll take it out of my personal name. So the deed of the house, instead of being this house is deeded to Kimberly Russell, it'll be this house is deeded to the Orange Frog Trust. And I can manage the house and have control of the house because I am the trustee of the Green Frog Trust. Does that make sense? Okay.
Can a business entity own your trust? Like your business could own your trust?
Yeah. And you can also have your trust have like your business interests, right? Say I have a PLLC, right? I can say this PLLC is the trustee. So it can be you or a third party that can manage the trust, right? It doesn't have to be you. But if you have a third party, it can be a business, it can be a corporate administrator, right? However, if you have a third party managing and controlling the trust, that diminishes your control over the trust. Even though you still, are probably, a trustee, or not a trustee, but at that point, you probably be a beneficiary of the trust, you won't have control or as much access to the trust as if you were a trustee yourself.
And I guess I only ask because it's like, if ideally, if I wanted the church to be my, do people do that? Like, do people?
Absolutely.
Okay.
Yeah, people do all kinds of stuff. Just depending on the circumstance, right? Your personal circumstances, who you would want to be trustee. And again, this person has control over all of your assets, everything you put into the trust, which is what funding the trust means. It must be funded. So you can create a trust, but if it doesn't have anything in there, it's just a piece of paper. It's just something that sits there. So you have to fund the trust, meaning you have to make a bank account in the name of the trust. You have to put your deed of the house in the name of the trust. You have to make the trust, if you want your life insurance proceeds to go there, you have to make the trust a beneficiary of your life insurance. And then you can distribute the proceeds however you wish. Ms. Martha?
Can you have more than one trust?
Sure.
Like if I want to leave one property to one child, another property to the other, and they be trustees over separate trusts?
If that's what you want, yeah. I mean, I wouldn't recommend it, but you can definitely have more than one trust, and we're going to go into later, there's different types of trusts, right? But yeah, you can definitely have more than one trust, but it just depends on the complexity of your estate. Like, do you own multiple real estate? Do you own like a lot or have a lot of assets, right? It just depends on what your personal estate kind of looks like. But the most important thing is every trust is going to have to be funded. No matter what trust you choose, it has to be funded. And funding means, putting your house in the name of the trust, putting your bank accounts in the name of the trust. Like I said, putting your trust as a beneficiary on the life estate, on your 401k, right? It has to be funded because the money has to come from somewhere. And if you don't put it in the name of the trust, it's just defunct. It's not going to do anything.
So what happens with the loan that's in your personal name, but you deeded the house to the trust?
So there is a law that says most mortgages, right, they have a acceleration clause, like if you sell it or change the name of it, but there is a law that says that they cannot do that. They cannot accelerate or trigger that acceleration clause. So the loan will then just go on as normal. You'll pay the mortgage as normal, but you might want to notify them, right? Especially notify your homeowner's insurance that it is in the name of a trust now, just in case you run into any complications. You can just notify them, but it won't affect the mortgage at all.
So when you sell the house, do the proceeds go to the trust at that point?
Yes, but you're the manager of the trust at that point, so you can do whatever you want with the proceeds, right? But so the proceeds will go to the trust. However, because you're the trustee, if you choose this type of revocable living trust, right, and you choose to be the trustee, then you have access to, and you can do whatever you want with the proceeds and the distributions from the trust. However, you can do it however you see fit. So also, just like a will with a trust, if you have a trustee, right, ideally, you would be the trustee while you're living, so you have access and control over the trust, over the assets within the trust. However, there will come a time when you won't be able to be the trustee. So it's important to have a successor trustee or someone else who can do the trust, who can manage and access and control the assets within the trust. And so just like you would think of an executor or as someone else who could be another executor, I would suggest and recommend the same process, right? Someone who you love, but someone who you trust to follow your wishes. Because A trustee has a fiduciary relationship with the beneficiaries of the trust, meaning there's a legal responsibility created when they are named trustee. And if they don't manage the trust correctly, they can be sued. They can be withdrawn as the trustee of the trust. So you have to make sure you're choosing someone you trust to manage the affairs of the trust. And once you pass away, if you have a revocable living trust, the trust then becomes irrevocable, meaning it can no longer be changed. And there's not a form anybody has to fill out. There's not something anybody has to submit. It just automatically switches to an irrevocable trust. It can no longer be changed. And as long as there's assets in the trust will remain. But once all the assets are depleted or distributed, then the trust ceases to exist. And again, there's no form to fill out. There's nothing else you have to do. The trust just ceases to exist once all assets are depleted or distributed, right? And that's for most trusts, right? Once the assets are gone, the trust is done. Okay, so next slide. So I guess you're questioning now, well, do I do a will? Do I do a trust? I'm gonna give you the classic answer for a lawyer. It depends. It depends on your circumstances, right? So if you have one house and one child and you're not married, you might not care to go through the trouble of deeding your house to a trust and putting your bank accounts in the trust and all this stuff, right? So a will might be sufficient for you because you just have the one child, you know they're getting everything, you trust them, you know the probate process won't be that long because you know your estate isn't worth that much, you know it might not be worth the trouble and the expense of doing a trust, right? So what's the real difference between a will and a trust? The first one is probate, right? A will has to go through probate. And it can be time consuming and it can be costly, right? A trust bypasses probate. It goes directly to the beneficiaries. As soon as you pass away, the successor trustee steps up into the primary trustee role, and they will distribute your assets to the beneficiaries as you have aligned or lined out in the trust. And it is more private. Another thing I forgot to mention, which I think is, I'll get in here, a will is public. If you have to go through probate, it then is, anybody can see your will, anybody can see everything that you have to upload to the court because those are public documents. A trust is much more private. And we'll get into more differences. Okay. Oh, privacy, yeah. A will becomes public record once it's filed in probate court, and a trust remains private because it doesn't go through probate. And if you name your trust something that doesn't have anything to do with you, right, it's going to be even more difficult for people to find out who owns it because their name isn't associated with it, right? So, again, you can name your trust anything you want. It doesn't have to be like the Russell Family Trust. It can be whatever the dead dog, whatever you want it to name it, you can name your trust so that you can have even more enhanced privacy. Next one. Wills versus trust. So a will, it only becomes effective upon death and does not provide for asset management during the testator's lifetime. So the testator is someone who wrote the will, right? If you have a will, you're a testator, right? That's the person who writes the will. And the trust can manage assets during the trustor's lifetime, providing for incapacity and specific terms of management. So, like I said, the will is only effective at death, right? You're already managing the assets, you know, like you're just living life, right? Nothing can happen with the will unless you change it or amend it, right? It's only effective, your wishes are done. Your wishes are completed and done once you have passed away. A trust, you can amend, you can change, you can still control, and while you're alive, right? You have more control over it. Even after you die, right? You can put very specific clauses in your trust. So if you know your nephew, you want him to have something, but you know he a little, you can make sure that he only gets it so often, or, you know, however you want him to have it, because you know his character, right? So you know how he is and what he does, so you can have more control. With the will, you can't really do that. You can give him a lump sum because there's no other way for you to give it in a will. You can give him a small percentage, right? And then maybe he won't do whatever. But In a will, you won't have as much control as you do with a trust. Next slide. Management of assets. A will provides instructions for asset distribution but does not manage assets before death. A trust allows for detailed management and distribution of assets, potentially with conditions for a specified duration. So like I was saying before, like if you want your cousin or your nephew to have this or that, but they, you don't trust them fully, or you have a minor, right? You have a minor child, and in North Carolina, a minor child cannot inherit. They have to have some type of specific guardianship, right? Which is another consideration for a will. I will say that you can name a guardian in a will, but you cannot name a guardian in a trust. But I will get to that later. There's a workaround for that. And so, yeah, you can do much more specific control of your assets with a trust. And not only now, but once you pass away. So what do you need? What do you want? Do you want the will? Do you want the trust? It just kind of depends, right? And the cost and complexity, right? A will, generally more cheaper on the front end, right? You might have to pay a lot on the back end, or your estate will. Trust, generally more expensive on the front end, right? Because you're doing a lot more on the front end, but on the back end, your family has that peace of mind that they're getting the property, they're getting the assets, and that is that, right? There's not much more expenses unless you kind of contact, or unless you have a third party administering or being the trustee of your estate, that there's not much, of your trust, that there's not much more expense associated with the trust once the initial trust is completed. The next one, creditor protection. So a will opens the estate up to valid creditors that are known and unknown. So when you put your will in probate, right, you have to, once a personal representative gets the letters testamentary, or the letters to say that they have the valid, or they have the authority to transact business, right? They then have, I believe, 90 days to put in a paper that is published countywide, that this estate is now open to creditors, and it has to be published for 4 consecutive weeks. And that can open you up to unknown creditors, right? You might have bills like, okay, I know that there's this hospital bill, I know that there's this credit card bill. Those are creditors that are known to you. However, if the creditors are looking in this paper, right, and they say, oh, I see this estate of such and such is now open, I'm going to then file it with the probate court. Now you gotta pay another creditor. And especially if it's valid. Some are invalid, but if it's a valid creditor, if it's a valid debt, you have to pay it. And it has to come out of the estate funds. Mm-hmm.
So you mentioned county again.
Yeah.
So now I'm wondering, I understand legal stuff is by state, but say I own property in a different state and I want to have that property in a trust I establish here.
Right.
Can you do that?
Yeah.
Okay.
Yeah. The wills is for county stuff, right? That's a will thing. You have to publish ad in the paper opening the estate to creditors within the county that you resided in or that you held property in. So if you have to do probate for whatever reason in that other state, then you'll have to do that there in that county, depending on the laws of that state. However, if you have a trust, it's private, right? It's not open to creditors because they will have no way of knowing that your estate is that you've even passed, 1, 2, that is open to anything, yeah. So that's another major difference between a will and a trust. It is creditor protection, right? You're just not opening yourself up to creditors knowing that your estate is open, right? And next slide. Okay, so that's the major differences between a trust and an estate. A trust and a will. So any questions about the differences between trusts? and wills. Okay. And before we go into the types of trust, a trust will also have to have a will as a safety measure. Because if you do not update your trust and you pass away, the assets that you did not put in the trust will have to go through probate. So what we recommend is that you do a will, what's called a pour over will, a POUR will, pour over will. And what that does is the will says, I leave all of my assets that are not contained in this trust to this trust. And so then that will still have to go through probate, but you won't have many things. There won't be lists of assets. It's still more private, right? But the thing is to keep your trust updated so you won't have to have that safety option, right? So we always recommend a pour over wills just in case you weren't able to update everything like you wanted to. And so everything that is not in the trust will fall to the pour over will, which will then fall back into the trust. And it can be distributed how you want it to your beneficiaries as you desired. And so what kinds of trusts? So we've been talking about a revocable living trust. And that's revocable, meaning it can be amended, it can be changed, it can be revoked, and you can then take all this stuff out of the trust, right? An irrevocable trust, it provides greater protection because it cannot be changed. However, it cannot be changed, right? Once it's in there, it's in there. Once it's done, it's done. And you can still be trustee. You can still have successor trustee, you can still fund it and all that stuff, but once you put that trust and once you put all those beneficiaries down, once you put people in, or once you fund it with your properties and your assets and bank accounts and stuff like that, it's done. That's it. And next you have a supplemental needs trust, which is it can provide supplemental support for a loved one with special needs while preserving eligibility for means-tested government benefits such as Medicaid or supplemental security income. The things about this kind of trust is Medicaid has a 5-year look-back period, meaning once they're trying to qualify you for Medicaid, they can look back 5 years to your assets and say, these qualify or don't qualify, right? Or these disqualify you or qualify you because you've had these assets for 5 years. So they can look back. So it's 2026. If you file for Medicaid, they can look back to 2021 and look at all your assets that you had in that meantime and say this disqualifies you or this qualifies you. They're going to do the sum of all your assets and all your bank accounts and all those things. So with trusts like these, when you're kind of trying to hide assets from Medicaid so you can qualify for Medicaid, you have to make sure that you do them in a timely manner because Medicaid will look back 5 years in order to see if you qualify for Medicaid or any supplemental Social Security income. Testamentary trust. So a testamentary trust is testamentary means upon death, and such trusts are created under a will and come into existence at your death. They use the will's instructions to govern how certain assets are managed and distributed. So you can create a trust within a will. Not recommended, but you can, right? Because it'll still have to go through probate, and then a trust will have to be created based on the instructions in the will, and then you'll have to name a trustee. Of course, it will not be you, but however, you'll name a trustee, and then the trust will go on from there. You also have charitable trusts, which charitable remainder trusts, and charitable lead trusts can provide income either to individuals or charities for a set period, with the remainder ultimately passing to a charity or other beneficiaries, often with meaningful tax benefits in the right situations. So say like this is Uplift Christian Ministries, you can create a charitable trust and have it come to Uplift Christian Ministries for a period of time, and then after that period of time, it can either go to beneficiaries or it can go to the charitable, or to the charity, or to Uplift Christian Ministries. Okay. A land trust, and this is just a trust that holds land, right? And it's usually and that's it. It holds land. It doesn't hold any other thing except land, and it's usually land used for investment purposes. So if you want greater privacy around your real estate holdings, a lot of people use a land trust. And then you have the Medicaid Asset Protection Trust. And it is an irrevocable trust used to shield assets so you can qualify for government-funded long-term care. By removing assets from your name, it helps you meet strict financial requirements without forcing you to spend down your life savings. So like I was saying with the other trust, the special needs trust, the Medicaid looks back 5 years. So just something to keep in mind if you're trying to create a trust for that purpose to kind of hide your assets in order to qualify. Make sure you do it in a timely manner so that Medicaid won't look back 5 years and say that still qualifies and now you created all this for kind of no reason. So as you get older, just something to think about, right? Yeah, so a special needs trust is kind of like for someone who, so her question was, is a supplemental needs trust different than a Medicaid Asset Protection Trust? And yes. So the Medicaid Asset Protection Trust is solely for the purpose of kind of qualifying or hiding assets for the purpose of qualifying for Medicaid. Yeah, they're still going to look back 5 years in every case. Medicaid going to look back 5 years. Whatever you're going to do, they're going to look back 5 years. Then, but for the Medicaid Asset Protection Trust is just to hide the assets, or to not hide them, but to make sure that they're safe, tucked away so that your family can benefit from your assets instead of you have to spend them down in order to qualify for Medicaid. Because end-of-life care can be very expensive, right? And so Medicaid helps offset that cost. And so you might not have the money enough to qualify for the end-of-life $10,000 a month kind of care, but you might have money that you want to leave to your people, right? You want your family to be well taken care of. And so you can put that into a Medicaid trust. The supplemental trust, needs trust, is for someone that you know has special needs and that you know is going to have, going to need lifelong care, right? And so you can put that into a trust. The Medicaid 5-year look back still applies, but that's more for someone who has special needs, someone who has, is going to need care even after you're gone, and you want to make sure that they're taken care of.
Okay, I just want to share something with the Medicaid part of it. I think my dad died in the 80s. In the early 90s. So we took everything out of my mom's name. So when she was dying, we didn't have to worry about the 5-year. But however, there were ladies in our community, the families had spent all their life savings building nice homes, and then they got sick, and they tried to take the home and put it in somebody else's name in their family because of the Medicare spend down, and the persons died before their 5 years. These people who thought they were leaving family homes lost their family homes, and the government did take their homes, and they are now out of their family dwellings. They can't sell it, they can't live in it, they can't do anything, and it's because they didn't take it out of their names in time, and Medicare had came in and had provided services for them, and their services are very expensive, and they want their money back, and that's how they get their money.
Yeah, that's how they get their money. So that's why the 5-year look-back period is super important. So the older you get, you might want to consider doing it now, right? Because you never know, you never know. Tomorrow isn't promised. We never know what tomorrow holds. So it's important to kind of look at that stuff. And if you want to, right, it's not a obligation. You don't have to do anything. But should you want to, it's important to do it now so that, like she said, the 5-year look-back period won't even matter, because by the time you need the services, it'll be well past the 5 years. Mm-hmm.
I understand that trusts are private, but is the trustee, whenever there's a trustee and the trustee's you trying to manage your own stuff, is that information that people can find anywhere?
No, because the trust isn't filed anywhere. So what happens with the trust is when you need to go, so you don't take the full trust with you. What you have is what's called a certification of trust, and it kind of summarizes what the trust is, and then you have a schedule, and a schedule A or B, depending on how many assets you have, and what's on the schedule is what's in the trust. So it's like a car, house, bank accounts, proceeds of life insurance, things like that. So you would take that with you to the bank saying, hey, I need to open up a trust. or a bank account in the name of my trust. Or so is nothing to be filed anywhere, so it's kind of hard for them to find it unless you put it somewhere publicly, right? Which you can, is your prerogative. But if you're interested in privacy, there's nowhere online. You don't file it with the Register of Deeds. You don't file it with the court. You don't file it with anything. You just have it with you in your important documents, like Dr. Val said, you just keep it with all your stuff, and then you make your wishes known, you make it known to your family that this is here, and that's that. So that's why it's so private. It's not filed anywhere. I mean, they can potentially dig, right? Oh, it used to be deeded to Shonda, now it's deeded to the Red Frog Trust. Well, what's this, But it'll be hard for them if you don't have anything else filed under the Red Frog Trust. If, and especially there's other things you can do to make it even more private, right? But, like I think Angela asked earlier, can your trustee be a business? Yeah, but then in Wyoming, you can do a LLC in Wyoming, and they're very private. You can't even see who registered for that, and then you can have that be the trustee. So there's a lot of things you can do to protect the privacy, which we can also talk about later. But, it can be very, very private, however private you want it to be.
I have a question about the land trust. Is that only for investment land that you purchase, or can it be for personal land that you own?
It could be for personal land, but it's usually, I'm saying generally, a lot of like real estate investors use that for to maintain privacy. But yeah, it can be for your personal land, but it's for land only. Yeah. Okay, so now that we know trusts, and now that we know wills and the differences, what do you choose? It's up to you. What do you think you want? What do you think you need? What do you value? What do you see like your assets going, or how do you see your beneficiaries inheriting your property, right? It's up to you. There's not a right or wrong answer. It's really up to you. And it's up to what you value, right? Some people really value privacy. Some people really value spending money later or not now. It's just up to what you want. And I can't make that decision for you. But you have all the information. You have now the understanding. You have the wisdom. And yeah, it just depends on your estate size and complexity. It depends on your privacy concerns, right? Your family dynamics. How's your family? Like, once you pass away, do you think they're bicker? Do you think they'll be more amenable to a will or a trust? These are things you're going to have to sit down with and talk to your family about. Like, what are your concerns with your family? The cost and maintenance, right? A will, you're going to have to update. A trust, you're going to have to update. They're both going to need to be updated, right? So what do you want to update? Which one do you want to go through probate? Do you want your family? You're not going to have to go through it, right? Or you might have to with your parents, or, with the loved one. You might be named executor or personal representative, and you go through their whole process, and you were like, no. It just depends on what you value and what you want, and the size of your estate. If you have lots of houses and lots of land and lots of money, you might consider a trust, because your family might be more protected, right? However, if you just have a bank account and a car, you might not want to trust. It might not be worth it to you. So yeah, I think it's just a personal decision based on what you want and what you need, and what your family wants and what they need.
I got a question. I'm assuming you have to get an attorney to get a trust completed, correct?
Not necessarily, no. There's, you got online trusts and will things, right? Or like Rocket Lawyer and, things like that. But I think it's important to sit down with the trusted estate planning attorney who knows the laws and rules of your state in order to, efficiently and effectively write it out and complete it. But no, you don't have to.
Second question, to continue on with that, once if you decide to go with a paid attorney to get your estate done or trust done or will, do you have to pay an additional cost to get it updated?
Yes.
Okay.
Yes. Yeah, you're going to have to pay either way. You're gonna have to pay to get it updated. Both will need to be updated, and it just depends on, what you want. It depends on also what's being updated, right? Is it, oh, I'm just adding a grandchild, or I'm adding 3 houses, right? It depends on what's being added and to what, as to the cost, right? So both need to be added, updated, both need to be amended, but yeah. The cost of maintenance, it kind of just depends on the size of your estate or the size that you intend your estate to get to, right?
So when you go in to make those changes, are you re-notarizing everything again each time?
Absolutely.
Okay.
Yeah. So what it's called is like when you do a will and you do an amendment, it's called a codicil, right? And then you kind of revoke. It depends on what you're doing or how you're amending it. Sometimes you're removing things, sometimes you're adding things, right? So sometimes you're going to have to revoke a portion, and sometimes you're just adding things. So you do a codicil to a will, or you do an amendment to a trust, and you'll either, you add or remove however you see fit. Yeah. Okay, so that's.
I have a question.
Okay, hi, Ms. McAuley.
Involve putting your land into a trust.
Okay.
Once you've done that, can you build on the land, or is there any type of situations you'll face, by doing that or confronting that issue, or what?
No, once you die, it's depending on what you put in the trust, right? And who you pass it to. Whatever they want to do is what they're going to do. There's no restrictions on whether or not they can build or whatever. It just depends on who you gave it to and what they decide to do with it, right? There's no restrictions on building or not building or selling or not selling unless you put that in the trust, right? So, yeah, it's whatever you put in there. And then it's up to whoever the beneficiary of the trust is once they receive the property. And I think I'll make it a little clearer. Once you die with the trust, it'll go to the successor trustee. They'll become the trustee, and then they will maintain and control the assets of the trust. They won't be able to change it. They won't be able to do anything. They'll just have to adhere to the will, or to the wishes of the trust, right? So they'll pass it out, the assets, as you put in the trust. However you designed it is what they'll do. And that's what happens when you pass away with a trust. And once all the assets are depleted, once all the assets are distributed, the trust ceases to exist.
I got a question. So what if something happened, God forbid, something happened to the trustee that the trust is left to before any of the proceeds or assets get distributed or anything like that? Is there, I'm pretty sure, I guess there'll be a third trustee?
Absolutely.
Or a second,
Yeah, I do recommend doing 3, which is, it can be hard to find 2 other people that you truly trust like that, right? But I do recommend doing 3 people. You'll be one, and then you'll have 2 successor trustees, just in case they're unwilling or unable, right? Unwilling for whatever reason, or unable because they passed or they don't have the mental capacity, no longer have the mental capacity, right? Whatever reason, I recommend 2, even for a will, I recommend 2 successor executors, and for a trust, I recommend 2 successor trustees, just in case. We want everything to go according to how we plan, but we don't have any say in that. We don't have any control. So I recommend 2, and it's hard. It's hard, right? Because you're going to be gone, and these people are going to carry out your wishes. So you're going to have to make sure these are people that really are going to do what you want them to do and carry out your wishes how you see fit, because, they have now control over all of your assets. So you want to make sure that they're doing what you want them to do. So you got to choose people that you trust for real.
Okay, so with that being said, so what if something happened, God forbid again, that your first trustee decides to say, hey, I don't want to do it?
Yeah.
Is there any legal documentations that need to happen for your supplementary trustee to step in, or is that just automatic?
It's automatic, yeah.
Okay.
It's automatic. and God forbid something happens to that one, right? Then the beneficiary is going to have to get together and say, we elect this trustee. And there's a provision for that in the trust as well. And it can be a third party, or it can be another, it's going to have to be a third party, right? But it can be someone, or it can be a company, it can be a bank, whatever they choose, right? At that point, they choose, because now they need to get their stuff, right? So they're going to have choose a trustee to distribute the trust, the assets of the trust. Okay, so now you decided you wanted a will or you wanted a trust. What else is in the estate plan? Financial, go down. Okay, yeah, financial power of attorney. So a financial power of attorney is, oh wait, is there another one above that? Oh, never mind, go down. Okay, financial power of attorney, or a durable power of attorney, right? So in North Carolina, there's two different power of attorneys. It might be the next slide, so let me be quiet. Financial power of attorney, no, it's not. Okay, financial power of attorney. So you got financial and you got healthcare. There's two different power of attorneys. And then again, this is a person that you must trust, and it can be the same person, right? It can be the executor. Doesn't have to be, but it can be. And this is a person you trust because they will have total access to all of your financial decisions, and they can make any financial decision that you would make on your behalf, right? And so what you're signing is broad powers, or it can be, right? You can give them access to everything, or you can limit access to what you only want them to have. So a financial durable power of attorney allows you to appoint a person referred to as your agent, or sometimes attorney in fact, to make financial decisions on your behalf, access your financial records, and take appropriate action to handle your legal and financial affairs. So, you know, we've all heard of a power of attorney. So what this person does is they transact business on your behalf while you're alive. A power of attorney, either healthcare or financial, is only effective while you're alive. What you can decide, though, is when it will take effect. It can be springing or upon an event, like say you're deemed incompetent or mentally incapacitated, right? It can be springing, or it can be effective immediately. Once it's signed, it's effective. So that's your decision, right? You can have it effective either springing upon some condition or effective immediately once it's signed. And then you would take it to your financial institutions and, you know, mortgage companies and stuff like that so that they can then transact business on your behalf. Again, this needs to be someone you trust. So, because they will have access to all of your funds. They will be able to pay bills. They will be able to transact business on your behalf without speaking to you, because you have given them the legal authority to have access to all of your money and all of your 401k and sell real estate on your behalf and all of these financial decisions that they can make and things that they can do. So you have to make sure it is someone you love, but always someone you trust to do what you want them to do. Same with the healthcare power of attorney. They will have, okay. Here we go. Healthcare power of attorney is allows a person to appoint someone to make healthcare decisions on their behalf when they can no longer do so themselves. The agent's duties, or agent are also attorney in fact. Duties include acting in the principal's best interest, adhering to the principal's wishes outlined in the healthcare power of attorney and any other advance directive, and communicating with healthcare providers to ensure those wishes are honored. So what a healthcare power of attorney does, you give someone, just like the financial power of attorney, you give them broad discretion or broad powers to act on your behalf when making healthcare decisions. So this includes whether or not to pull the plug, whether or not to keep you artificially hydrated or artificially fed, right? To, you know, there is a basic care and comfort clause that every nurse and doctor has to follow. They have to keep you clean, they have to keep you comfortable, and they have to keep you pain-free. But other than that, you get to decide what else, right? Do you want to live this? Do you want to be, like, how long do you want to be in a coma? Do you not want to be in a coma at all? Like these, what these are called, these kind of decisions that you have to make for end-of-life care, these are called advance directives. And there's two kinds. One, well, there's multiple kinds, but one is a healthcare power of attorney. And this gives you the person acting on your behalf, which can also be effective. It's only effective while you're alive, and it also can be effective upon a condition, say you're deemed incapacitated, or it can be effective immediately. And it just depends on what you want in that situation. However, they have broad discretion to, if you are unable to make the decision, or then they will make your healthcare decision on your behalf. So it has to be someone you truly, truly trust, and that they know what you want and they will do what you want, because sometimes we love people and they love us, but they're not going to do what we want, right? Because they love us too much. They want us to live. But you, in a certain situation, you might not want to live in that kind of, you don't want that quality of life, or you don't want that, that for your life. So it's important to choose someone that will do what you want, that will follow your wishes when doing a healthcare power of attorney. And the next one is the Advanced Healthcare Directive. And so this is also called a living will, and this is just kind of, it gets more in the weeds, right? So a healthcare power of attorney is kind of broad, like they'll consent to a surgery or stuff like that, and it can be as broad or as limited as you want. But the Advanced Healthcare Directive or a living will kind of goes into what happens when you start to have, or if you start to have, a mental cognitive decline, right? How do you want to be cared for? Do you want to be cared for? Like, what happens if you're in a vegetative state? Do you want to be fed artificially? Do you want to be hydrated artificially? How long do you want to remain in that state? And these are hard questions, because this is your life and you're considering how it should end. And that's not easy, right? It's not easy to think about your life ending and how you want it to end. But also just remember how you want your quality of life to be, because we're all going to pass away, right? We're all going to transition. So we need to make sure we're doing it the best way we know how. So kind of sit with those questions, right? How do you want the end of your life to look like? Do you want to be in a vegetative state for a while? Do you want them to resuscitate you? These are questions that you're going to have to ask yourself, and these are questions that you're going to have to, or decisions that you're going to have to tell your loved ones so that they can follow it, right? They need to know this beforehand. They don't want to go to the doctor and be given you're in a coma, right? And they're all nervous and crazy and grieving, and they're handed a form like she said, don't resuscitate. And they're like, what? Right? You need to discuss this with your family. It's very important beforehand, and let them know that you don't want to be resuscitated, or you do, but only so many times, or, let me live as long as I can live, right? Or no, pull the plug. Whatever it is that you want, you have to decide, and you have to communicate that with your family. And then whoever you choose to be your healthcare power of attorney, make sure that they will follow your wishes, because if they decide something that's not in line with what you would want, then you might be alive and not have the quality of life that you would want, because you didn't make your wishes known. So that's why we're doing this. That's why we're doing the Advanced Healthcare Directive, because it gets even more in the weeds and even more specific about, I don't want to be fed artificially. Let me go on to glory. Let me go be with the Lord. It's a little more in depth, but there's questions that you'll have to ask yourself and that you want to know for the end of your life. And it's not always easy to consider that kind of stuff. And this is also effective immediately or upon some kind of incapacitation, and it is only effective while you're alive, right? So once you pass away, it is done. They no longer have a power of attorney, because who are they transacting business on? Then they'll go through the executor or trustee process. But at this point, they're no longer a power of attorney. Once you pass away, the effectiveness ceases for all power of attorneys and for the Advanced Healthcare Directives. And the last thing you need is a HIPAA release form. And so that just allows them to, call your doctors and call your pharmacy, and get things, know your diagnoses, know what medicines you're taking, so they don't always have to bug you or bother you, right? You can give this to your doctor, give this to your medical providers. And it's just, because they're by law required to protect your personal health information, or your PHI, right? And because they have to protect it, they can't just give it to anybody. You can't just call up and say, okay, my mom's doing this, what medicine she's on. They can't give her that information or give you that information. So this is just another way to ease the path of you having more information. And it's really just a form. You sign it, they sign it, and it's notarized, and you give it to the medical professionals. All right. So that is all of what should be included in your estate plan. So that's a will or a trust, or a will and a trust. The healthcare power of attorney, financial power of attorney, advanced healthcare directives, and the HIPAA release form. And so here's some frequently asked questions. Are there other ways to avoid probate? Yes. I mentioned some earlier. There's, you can do bank accounts with joint ownership and rights of survivorship. Same with deeds. You can do payable upon death. There's certain things that if it goes straight to a beneficiary, like life insurance, that avoids probate. So yes, there are ways you can avoid probate. Can I disinherit someone? Of course. You can, unless you don't have a will, right? Then it's going to go to your heirs regardless of what you want. You have a question?
Yeah, everything that you said, I have that because I was looking at that before we came here. This HIPAA form.
Yeah.
Who gives you that HIPAA form?
You can get it from your medical provider. And I also provide HIPAA release forms. So yeah, you can get them from your medical care provider, or I can give you one if you want. I'll give you one, Mama. Yeah. So any other questions? What happens to my life insurance and investment accounts? So if you have named beneficiaries on them, the proceeds go straight to the beneficiaries. That's it. Unless you want it to go to you want to name your trust as a beneficiary and then have more parameters set around the proceeds that way, but it will go to the named beneficiaries, period. So make sure you're updating that as well. Like Dr. White said, update, because you don't want someone out who's dead, someone who's you're no longer married to, or you might have a child, now you want them on there. So make sure you're updating everything. That's just not the will, that's just not the trust, but that's also your beneficiary designations as well. Is a handwritten will valid? Yes, however, only in very limited and very specific circumstances. So just write it out. Make sure you get it really notarized, signed by those two disinterested witnesses, and having the self-proving affidavit stating that you're over 18 and of a sound mind. So yeah, make sure that you have that. It's just easier. You don't want to go through the hassle of a written will. There's also things called nuncupative wills, which is an oral will, but it can only be valid upon your deathbed. You have to be just about to die. And then you can state all these things, and it has to be witnessed by these many. That's a lot. Just get the will, right? There's certain things that are valid in North Carolina. However, there's lots of hoops you're going to have to jump through. So yeah, just get a regular will. Does the state take my assets if I don't have a will? You don't even know how many times I've been asked this question. No. The state does not take your assets. If you don't have a will, like I said before, it'll pass through intestate succession, meaning you don't have a will, and succession meaning those are the heirs, right? So it'll go to whoever the law states out who your heirs are, right? And then you have to go to probate, and you'll submit to them all the heirs, and you'll have to list, you won't believe how many people you'll have to list. You'll have to list your nephews, your great aunts. Did they have brothers? Like, you'll have to list everybody, and then it'll go to your heirs, right? Because some people have died, it might skip them, and it'll go to them, to their children, and then you have to split it. It's a lot, but yeah, it will not go to the state. And very, very, very rare and limited, if they cannot find anybody who is related to you, it'll go to the state. That's the only circumstance, but most of us, we got cousins, we got people, so it's not gonna go to the state.
So can all these documents be done on an individual basis through downloadable forms, or is a lawyer necessary?
Yeah, they can be done on an individual basis. Downloadable forms. The North Carolina has actually statutory forms that should be accepted throughout the state, right? And the full faith and credit clause of the Constitution makes sure that it not only will it be accepted in this state, but in every other state. So yeah, North Carolina definitely has statutory forms, specifically of the durable power of attorney or the financial power of attorney and the healthcare power of attorney and the actual advanced healthcare directives. They have statutory forms that were set by the North Carolina legislature. So yeah, they have those downloadable. I think it's nclegs.com or .org, I can't remember, but yeah, you can go and download them and do them yourself and notarize them, make sure they're signed by witnesses, and some require witnesses, some don't, but yeah. And then you make sure you check the box on how you want it to, or when you want it to become effective, upon a condition springing or upon immediately. And then, yeah, that's that. And then you give it to your healthcare providers.
Thank you.
Okay. Yeah. Any other questions?
And one more round of applause for Dr. White.
One more question.
Yes, sir.
Do you have an idea, or can you share an idea of the cost involved in a will versus a state here in North Carolina?
Sure. So, will versus trust. So, a will when I recommend all the estate documents, I would say we're probably run you around $1,000, between $1,000 and $1,500, and a trust will run you depending on how many assets you have. It'll probably start around $3,500. Yeah. Oh, and one last thing. If you're on a budget and you like, what should I get? Budget, what's the thing that I need most? I would say get the healthcare power of attorney and get the financial power of attorney, because we know there's going to be situations in which we're incapacitated. And incapacitation doesn't mean like it can mean you're in a coma, but it can also mean you're under anesthesia for surgery, and they're like, oh, we found this thing. We need direction, right? And so that doesn't mean you're necessarily like in a life-threatening situation, but it also means that you're unable to make the decision for yourself. So I would say bargain basement, the things that you definitely need are the healthcare power of attorney and the financial power of attorney. And if you can get it, the advanced healthcare directive, HIPAA release form, you can get that anywhere. But, at bargain basement, I think you need those documents for sure, because you want the end of your life, or, you want someone making decisions on your behalf. You want the best decision made. You don't want the doctor making it, and you don't want, some random person deciding how your life, something that could really affect your quality of life. So I think those 4 documents are what you really need, bargain basement. Okay. Oh, yeah. Yeah, it's a one-time fee at the beginning, then as you update it or amend it, and then that's the fee. Yeah. There's not, unless you hire a third party to administer the trust, then there's no like yearly fee or anything. Right, yeah. They would go ideally back right to the person or the attorney who created the trust, and then update it, amend it, or revoke whatever needs to happen, and then, yeah, they'll go from there. Mm-hmm. All right, thank y'all.
We want to thank our presenters, Dr. White and Attorney Russell. I got to get used to that last name. I think this was the conversation we needed to have. Am I correct? Yes. And sometimes we have personal stuff, so I'm not advocating who you go to, but I just want you to know that if you would like to seek the help of Attorney Russell, I have her business card, and you can give her a call, and she will make an appointment with her, and she will sit down on an individual base where you can talk about your own needs. The trust that I have, if something happens to me, the attorney's name is there. his phone number's there, and the person who I've delegated, they know. You have to let somebody know too that you have this and where it's kept. And listening today, especially to Dr. White, I know now I need to go back and do some more stuff, and and with Attorney Russell. Yeah, I want to go back and reread it because it was written over 3 years ago, and I want to make sure I dotted my I's and crossed my T's because I want things to go where I wanted to go because it was my money. It ain't their money. But anyway, on behalf of the seasoned saints and Miss Martha Hammond and myself, we would like to say thank you for coming. And for those people online, if you know me, reach out to me. If you want to talk to Attorney Russell yourself, and I can get you her phone number. And for those who are here, we have light refreshments, and they'll still be around if you have other questions. And I just want to say thank you so much. And if you've enjoyed this and think other people could benefit from this, let us know, and maybe we will do this again in another year. Okay, thank you. And we would like to thank Angelo for helping us out today. You said what? You like a card? Okay.